Thank you, Mr. Chairman. As noted, today we're examining sue and settle agreements between environmental advocacy groups and federal agencies, and I'd first like to thank our witnesses for appearing and look forward to your testimony and your answers to our questions. Sue and settle phenomenon refers to a process where outside activist groups will sue the federal agency for violating a provision of federal law. It's not just federal agencies, it's state and local governments as well. It's been going on for quite a while. First came to my attention in around 2004 when Senator Lamar Alexander of Tennessee introduced the Federal Consent Decree Fairness Act. What happens in these lawsuits, I think the witnesses well know, but I'll go ahead and explain that. The parties will often choose to settle by entering into a consent decree rather than facing a trial. In many of these cases, it's apparent that the agencies collaborate beforehand with the groups to set up the terms of the decree without public notice or third-party input. These are legally binding agreements that are approved by a judge, and they're enforceable by contempt and can only be modified by court order, which takes them completely outside the legislative process and the administrative process. These agreements can last for decades and end up costing more than if the parties had gone to trial. There are numerous examples of this, and they're broad in their application, whether it's education, consent decrees involving environmental issues. We've had them in Alabama. As a matter of fact, the largest bankruptcy in the history of North America is Jefferson County in Alabama. It all started with a consent decree involving our storm sewer system. Because these agreements can set provisions that extend beyond the scope of the original law violated, and I want to emphasize that, they can, because it's a consent decree, and the whether or not the defendant is ever in compliance is determined by a control group or a special master. These things can extend beyond the original complaint. They're an effective tool for advocacy groups to unilaterally dictate the priorities of an agency's agenda or a local county commission or a city council or a state for that matter. They're also done outside the Administrative Procedures Act. In February 2017 report, the GAO, the Government Accountability Office, found that 2 environmental groups, the Center for Biological Diversity and Wild Earth Guardians, filed more than half of the Endangered Species Act deadline suits between 2005 and 2015. According to GAO, these suits resulted in more than 1,600 actions affecting 1,441 species in just a 10-year period. Comparatively, the GAO found that only 76 species have been delisted since the enactment of the Endangered Species Act. Even in these cases, 19 of these species were delisted because of data errors in the original listing, and only 47 occurred as a result of recovery efforts. This indicates that the structure of the Endangered Species Act is not conducive to its purported goal. These actions place an enormous burden on states, local governments, industry stakeholders, and taxpayers who are shut out of the negotiations but are left to foot the bill. Moreover, interest groups can petition the government to cover their attorney's fees through the Department of Treasury's Judgment Fund, which is a permanent, indefinite appropriation of taxpayer money for payments of certain final judgments. Consequently, American taxpayers are paying the legal costs for groups that are suing them. This does not even account for the funds that are expended by the Department of Justice to provide representation for federal agencies entering into these lawsuits. The public is kept largely in the dark throughout the process, and few resources are available to inform them of what is happening and who is responsible. I dare say the vast majority of the residents of Jefferson County had no idea that this all began with a consent decree. Because of the incomplete data and lack of proper categorization, we are unable to fully evaluate the total amount taxpayers pay out as a result of settlement agreements. For example, in my previous experience in leading an Alabama think tank, I was unable to obtain a complete list of all federal consent decrees that apply to the state from the Department of Justice because of inadequate record keeping. This lack of transparency limits our constitutional duty to conduct oversight of management of taxpayer resources. I've heard too many stories from state and local officials where special interest attorneys dictated critical actions ranging from pipe sizes to bridge infrastructure instead of engineers and administrators, with specific expertise or private citizens whose homes and livelihoods were compromised. I've heard too many stories where state and local governments and their citizens are forced to reprioritize billions of dollars in resources by those in Washington who claim to be serving the public's greater interest. In cases where settlement agreements fail to accomplish their stated goal but their terms remain in effect, there is absolutely no accountability. It is time for the federal government to move away from emphasizing its role as prosecutor or political monitor and return to serving as the American people's partner in setting priorities that best represent their interests. I'm encouraged that the committee is highlighting the important aspect of sue and settle. I look forward to today's hearing as an important first step in examining these practices, and I yield back.
Thank you very much.